Pollution legal liability is important to the energy industry because just like all things, the CGL policy and the control of well policy don't cover every potential loss. Pollution fills the gap. Whether you're an oil and gas operator, whether you're a refiner, whether you're a terminal, there are certain inherent risks that are not covered by your CGL policy. So the pollution policies serve to fill those gaps and give you complete protection. In addition to that, within the last 12 to 18 months, we've had a number of court cases that have come down that have really changed the face of the CGL. We now have 2 cases that give us very clear interpretations of what the care, custody, and control exclusion is and how it gets applied, and how the pollution endorsement and underground resource damage coverage gets applied as well. Those have served to narrow the gap in what's provided coverage-wise under the CGL. So it's essential that they have pollution coverage to fill those gaps and give their company complete protection. The biggest gaps that you have in a CGL policy with respect to environmental tend to be gradual long-term issues. Things like exposure to air emissions over a long period of time, consumption of drinking water that is contaminated. We've seen that in Flint, Michigan, but there's always the potential when you're operating a refinery, when you're operating an oil or gas well, to also potentially contaminate groundwater. It's very few and far between. That does not happen often, particularly in the oil and gas production sector. But there is that risk. If the casing fails, you could put contaminants in someone's drinking water. And when you do that, that falls outside of the typical coverage that you would get under the CGL. So you have a substantial gap that can result in significant dollars for defense at minimum. And heaven forbid you actually get a judgment. If you get a judgment, then you're not only looking at significant defense dollars, but also you're going to be paying for somebody's drinking water for a number of years, as well as any bodily injury that they may have suffered, and medical monitoring potentially for the rest of their lives. If you get so stressed on your balance sheet because of an uncovered event, whether it's a pollution event or a bodily injury claim, a death on your job site, potentially that can put you out of business. We saw that with Freedom Industries in West Virginia. Now granted, that was not a energy company, but they had a release into the river in West Virginia. That company has now filed for Chapter 11. So that really puts the onus back on the taxpayers to deal with those long-term pollution issues. It's one of the things we keep talking about, and one of the conversations we keep having with local regulators, particularly in Texas, with respect to the oil and gas production operations. There's this movement of people saying, not in my backyard. And our position, and what we've tried to educate the local leaders on, is there's a solution. Your economy and your local economy needs the jobs, needs the revenue that come with oil and gas production. You can protect your constituents. You can protect your population in that city by simply requiring that oil and gas driller to have proper insurance, to have gradual pollution insurance. That way, if something does go wrong, you've got a pollution policy to fall back on to make sure your citizens are protected.